Скъпи посланници, които сте с нас тази сутрин, уважаеми дами и господа, уважаеми професор Жалимас, за мен е удоволствие да открия тази международна конференция, посветена на правата на ЛГБТИ общността в Европа. Днес, всъщност аз имах тотално различна реч за това откриване тази сутрин, която в рамките на вчерашния ден трябваше да бъде променена. Защо в рамките на вчерашния ден? For translation, you can also take the headphones. I'm sorry, I had to start with this. So the opening will be for me in Bulgarian for the first counselor of the French embassy in English, and then we will continue the panel in both languages. Трябваше да променя речта си от вчера. Защо от вчера? Защото вчера всъщност ние като гражданско общество бяхме подложени на една поредица от атаки, които, както говорихме и в кафе паузата преди началото, са по модела на други атаки в други държави. Малко контекст. През август 2024 година в две изслушвания в един и същи ден беше гласуван закона за предучилищно и училищно образование, който забранява така наречената в кавички ЛГБТИ пропаганда. Концепция, която не съществува в нашето право, но съществува в едни други авторитарни контексти. Има и в поредица от опити да се прокара така наречения закон за регистрация на чуждестранните агенти на няколко пъти в последните години. Отново нещо, което е характерно и за Унгария, и за Грузия, и за други още по-авторитарни режими. В рамките на вчерашния ден, всъщност, какво направи правителството, освен всички опити така да се задвижат различни процеси. От една страна беше предложена забрана и огромни глоби за неправителствени организации и лица, които работят в училищни институции, в училища, изобщо свързани с образованието. Също така беше и мина комисия на първо четене, комисията Сорос, която всъщност целта е да разследва фондации, финансирани в миналото от фондациите на Джордж Александър Сорос. В този контекст, в последната една година, горе-долу, се сблъскваме и с опита да се прокара религиозно образование като задължително такова в училищните предмети. Не ми се щеше да откривам по този начин, но неизменно това са неща, които са свързани с ЛГБТ правата. Свързани са през призмата на това, че всяка една от тези стъпки, предприети в последната година и половина, и не само тази година и половина, но преимуществено видимо сега, атакуват върховенството на правото, атакуват принципите на демокрацията, атакуват всеки нас от тук присъстващите и не тук присъстващите, които се опитваме да причислим България към западно развитите демокрации, изобщо към развитите демокрации, а не да живеем в авторитарни режими. Благодаря ви, че сте тук, особено днес. Надявам се в рамките на днешния ден още по-добре да очертаем проблемите, с които се сблъскват ЛГБТ и общността в България през призмата на правото. И давам думата на първия съветник на Френското посолство, мадам Ан Шарлот Монтен.
Hello. Ladies and gentlemen, dear colleagues, dear friends, it is an honor and a pleasure to open this international conference devoted to the rights of LGBTIQ+ people in Europe, and to welcome you all today at the Institut Français de Bulgarie. I'm particularly honored by the presence of Ambassador Irene Maria Plank of Germany and of Ms. V.М.А, Deputy Head of Mission of the Embassy of Austria. Your presence here today reflects our shared European commitment to dialogue, equality, and the rule of law. Allow me also to thank the organizers, the association Deist Vier, with the support of the Transatlantic Foundation's Proteus project, co-funded by the European Union, for convening this very important gathering. I would like to acknowledge as well the distinguished speakers who are going to join us, Professor Dainius Zalimas, a member of the European Parliament and former chairman of the Constitutional Court of Lithuania, Mr. Jonko Grozev, lawyer and former judge at the European Court of Human Rights, Mr. Adam Bruton, policy advisor at the Council of Europe, and all the scholars, legal practitioners, and civil society representatives contributing their expertise today. This conference addresses a question at the very heart of the European project: the rule of law and the effective implementation of European court rulings. The rulings of the Court of Justice of the EU and of the European Court of Human Rights are not mere legal texts. They embody the shared values and principles on which our union is founded, values that all member states have committed to uphold. The effectiveness of European law rests on the common commitment of member states. The full implementation of these principles strengthens the rule of law in each of our countries and reinforces the mutual trust that underpins our common European framework. Where challenges arise, dialogue and cooperation remain essential to ensure that rights are effective for all. France remains fully and firmly committed to these values. Through legislative advances, including the opening of marriage to all couples and reinforced protection against discrimination, and through its engagement within the European Union and the Council of Europe, France continues to promote equality, protect every individual from discrimination, and defend the independence of justice. The rule of law is not an abstract concept. It is the guarantee that rights exist not only on paper, but in practice, for every citizen in every country. I would also like to recognize the essential role of civil society organizations whose dedication and perseverance make such progress possible. Their work strengthens democratic participation, supports vulnerable communities, and builds bridges between institutions and citizens. I would also like to address a special word of thanks to the students of law who have joined us today. You represent the next generation of judges, of jurists, of advocates, and policymakers. You will carry forward the principles we are discussing today: the defense of justice, the protection of fundamental rights, and the integrity of the rule of law. Your presence reminds us that these principles are not only legal foundations, but also civic duties, embodied in the daily work of those who choose the path of law and public service. I'm proud that the Institut Français de Bulgarie can host this dialogue, true to its mission of fostering knowledge, culture, and understanding. Beyond this conference, we will remain committed to dialogue and capacity building on rule of law and fundamental rights. France will continue to stand with institutions, academics, and civil society organizations who work to make equality, justice, and fundamental rights a living reality for all. I regret, on a more personal note, that my diary today does not allow me to remain for the full conference, but I am confident that your expertise and commitment will lead to rich and productive discussions. I wish you, therefore, a very fruitful conference. May your exchanges contribute to strengthening the foundations of our common European family, one built on law, dignity, and solidarity. Thank you very much.
Thank you. So I'll ask the panelists from the first panel, please be on stage. Mr. Teodor Slavev from the Bulgarian Institute for Legal Initiatives, Mr. Professor Jalimas, member of the European Parliament, Esther Polgari, Hatter Society, and Mr. Yonko Grozev.
Добро утро, суросоиди. Готови ли сте да свидетелствате пред комисията, която вчера управляващите така набързо създадоха? Опитвам се да започна с тази шега за разчупване на реда, защото темите, които ще коментираме през деня, са доста сериозни, но всъщност са и много навремени предвид ситуацията в България, Европа и въобще в по-широк план. Аз се казвам Теодор Славев, програмен директор съм в Български институт за правни инициативи и за мен е чест и удоволствие да водя първия панел. Your Excellencies, members of the European Parliament, the National Parliament, the elected officials, guests, it's been tough times recently, not only in Bulgaria but also in this part of the world. As we have foreign guests here, probably I should say that Surusuit is a derogatory political label that is used predominantly in Hungary, Bulgaria, North Macedonia to describe civic activists, also members of the LGBTI QI plus community, and blame them for all the world's evils. Which is actually a tactic, a scenario that is used to exert foreign influence. These social technologies for disruption used for the first time in this modern way by Russia, but also applied in other countries, the United States and as well as in the Western democracies. The Kremlin playbook is very well known and studied. In Bulgaria, it started with, it was politically streamlined with the Istanbul Convention and all the craziness that it brought. And as Denisa said, it continued last year with the first amendments in the law since the democratic transition in Bulgaria that actually restrict human rights. And it continued. Yesterday, an investigative commission in the parliament was established. It was sponsored by Delian Peevski, an oligarch sanctioned for corruption by the United States and the United Kingdom, to investigate allegedly influenced by George Soros and his foundation in Bulgaria. This topic comes periodically, usually when the government has some tough times, as it's currently with the budget and some other developments in the country, but it's again used to blame whole communities, whole parts of the society. So, if there is no reaction by the European Commission and some other, and the other international partners of Bulgaria, I'm afraid that the situation in Bulgaria with the rule of law and with the rights is going to worsen, as we have observed in other EU members. And people in these panels, the first panel, are very well acquainted with the instruments to counteract such negative developments. So let's hear what they have to say, right? It's my great pleasure to introduce Associate Professor Esther Pulgari, a legal scholar and human rights expert from Hungary. She is affiliated with the Hatha Society, the leading LGBTI organization in Hungary, and is widely recognized for her research on the rule of law, the role of courts, and democratic backsliding in Central and Eastern Europe. Esther was an associate professor at the Central European University before he needed to move out of Hungary. Beyond her academic work, Dr. Pulgari has been an active voice in civil society, contributing to the defense of human rights and the values enshrined in European law. In her talk today, she will take on what she described as an almost impossible task: to discuss the role of the Court of Justice of the European Union and the European Court of Human Rights in upholding the rule of law in Hungary. Hungary's steady backsliding in this area is well documented, and its path has been marked by a series of judicial decisions that expose ongoing violations of EU law and human rights obligations. Esther will address two central questions. The first one: where and how have the Court of Justice of the EU and the European Court of Human Rights intervened as external checks on Hungary's increasingly liberal and autocratic agenda? And second, what do recent developments, including the Advocate General's opinion in the case of the European Commission versus Hungary and the Court of Justice of the EU's ruling on Deldit's case, suggest for the future, and might they signal a cautious hope for Hungarian human rights defenders? As she will emphasize, the Hungarian case is not only about the member state, it raises a broader question for all of Europe. Can a country hollow out the substance of EU and human rights norms domestically, yet still remain in the club called the European Union? Before I give the floor to Esther, some service information. There is translation provided, so our panelists, please speak slow but concise, because you have 10 to 12 minutes for your statements. And then we will have something like 30 to 40 minutes for questions from the public. Esther, the floor is yours, please.
Thank you very much. And as Theodor kindly saved a few minutes for me with telling you the introduction, I can start with this impossible task of describing how Hungary backslided when it comes to the protection of human rights and the rule of law, both within the European Union and in the Council of Europe. And over the past decades, Hungary's legislative and administrative practices have repeatedly collided with EU law in key areas such as judicial independence, media pluralism, civil society, asylum, and rights protection, just to name a few. Sadly, these actions are not random, so they are part of a well-orchestrated plan of building what the Prime Minister calls as a liberal democracy, but what in reality is rather a legal autocracy or electoral autocracy, as the European Parliament called it. So if we follow the playbook of the Hungarian government, let's see what we need to do and how can the European institutions react to that, and to what extent they are successful in their intervention. For the first step of an illiberal cookbook is how to roll back checks and balances. Checks and balances are painful for an authoritarian system, so they need to do something with it. And this was realized by the Hungarian government very quickly as well. The ruling majority swiftly enacted laws that changed judicial structures, self-governance mechanisms, and reshape judicial appointments to weaken judicial independence. The Hungarian Supreme Court, which is now called Kuria, and the Constitutional Court were quickly overtaken by government appointees, and they were rendered less protective of the rule of law. And European institutions did respond, so we can't say that they remained silent. The European Court of Human Rights in 2016 found that removing Hungary's former Chief Justice, András Baka, who was previously serving as a judge on the very same court, was in violation of the European Convention on Human Rights. Although he remained in office as a judge at the Curia, his former position was never reinstated. The Court of Justice of the European Union in 2012 found that the forcible retirement of judges and prosecutors violated EU law. It was age discrimination, but only a few of them returned to the judicial benches afterwards. The full implementation of these judgments remains incomplete, and the damage to the rule of law is not redressed. But this is just about judicial independence. Control over the media and control over the narrative is essential for authoritarian systems. So the government has taken over the media landscape gradually, and now it is fully state captured. The European Commission did intervene and started infringement proceedings, such as in the case of an independent radio that lost its license in 2014, like 11 years ago, but we still don't have a judgment from the Court of Justice until today, although the Advocate General affirmed the violation of EU law earlier this year. Civil society organizations are critical voices and thus burdensome for an oppressive government. They are definitely a pain in the neck for them. So the next area where Hungary clashed with EU law was in the field of harassing civil society organizations. The 2017 foreign agent law, which was a very light one compared to what Bulgaria is proposed to have or what we are proposed to have, was found in violation by the CGEU of EU law, and it was repealed in 2020, only to return in a much harsher form of a transparency bill earlier this year. That is pending before the parliament, but if passed, that will starve and strangle civil society organizations financially and operationally. It is a foreign agent law which is modeled after the Georgian one. We also have the Sovereignty Protection Office, which is a constant tool for harassing civil society actors. The funding legislation, the Act on the Protection of National Sovereignty, is subject to an infringement procedure. It's in an accelerated procedure before the CGEU, yet we don't have anything, so we are still living under the fear of being investigated by the Sovereignty Protection Office. And we are hoping that the Court of Justice will render a judgment before the parliamentary majority can move forward with the new one. Autocracies, like the Hungarian one, thrive on societal polarization, and Hungary has exploited anti-migration rhetoric to mobilize support. The government's policies blatantly violate EU law. It's probably something that you learn in the second year of in your law school. And the Court of Justice agreed in 2020 when it found that the Hungarian asylum system is non-compliant with the regulation of the European Union. It doesn't provide effective remedies. It authorizes forcible pushbacks. And at the time, we still had the transit zones. The government contested the judgment from the very beginning, refusing to implement it. And this led to over 400 million euros in fines against Hungary, which is increasing with 1 million euros every single day. that the judgment is not implemented. And if migration doesn't work as an external enemy, find a domestic remedy, and that's what the Hungarian government did, drawing on populist slogans like protecting children in order to crack down on LGBTQI rights. The 2021 anti-LGBTQI propaganda law restricts minors' access to content on sexuality and gender diversity, violating secondary EU regulation, EU law, and also the Charter of Fundamental Rights. The European Commission very quickly reacted. An infringement procedure was launched 2 weeks after the law was passed, but we still don't have a judgment from the Court of Justice, so 4.5 years passed, and pretty much a generation grows up without having comprehensive sexual education in schools. Gender minorities face even steeper hurdles. Hungary banned legal gender recognition formally in 2020, and Europe remains silent. The European Court of Human Rights did deliver already judgments relating to the situation prior to the ban, when the procedure was formally available, but it was suspended. It found a violation of Article 8 of the Convention, and emphasized that states have to provide a quick, transparent, and accessible procedure for legal gender recognition. Hungary and the Hungarian government remains unresponsive. And the cases we submitted after the formal ban was introduced, we have 87, for example, pending before the court. They have been, like a first batch of cases was communicated 2 months ago, so we won't have a judgment in the next year or so. And we see that when it comes to politically sensitive cases decided by the European Court of Human Rights, Hungary only partially complies. They pay the just satisfaction without much ado, but no general measures are adopted, so the rights violation persists. So you would ask whether there is any hope, or why human rights defenders remain active in the field despite all the government action trying to make their life miserable and their work impossible. And I would say yes, there is hope. And there are 2 things that I would like to emphasize. One of them is the Dardich case. That was our case together with the Hungarian Helsinki Committee, where the Court of Justice in March this year, found that the GDPR's right to have one's data rectified if they are incorrect applies to the gender marker as well, which opens a whole new basis for domestic litigation for us, and we hope that it will make some changes to the community. In the individual's case, who was our plaintiff in the domestic procedure, the asylum registry was changed, so his gender was changed there, and in the meantime he got citizenship as a refugee, and he got a new ID card, so at least the individual redress is on the way. And the other major development this year was the Advocate General opinion in the propaganda law's infringement procedure, which, if followed by the CGEU, could be a landmark decision, reaffirming respect for EU law and the values on which the Union was founded. And whether Hungary will implement it or not, that remains an open question, and I have doubts about it. But such a ruling could serve as a significant step toward holding Hungary responsible and accountable for its violations, and restoring respect for human rights, not only in Hungary, but also within the European Union. Thank you.
Thank you very much. As we talked prior to this panel with Teste, they will have elections in 4 or 5 months, so our fingers are crossed that you'll be back on the path to restoration of the rule of law and democracy. So, and I hope Bulgaria one day will be on this path too, but we'll see what will happen. Now, we continue with Denica Ljubanova. She is going to speak more about the Bulgaria's ongoing democratic backsliding, reflected in the weakening of the judicial independence, the erosion of media freedom, and the decline of institutional accountability that has had a direct and serious impact on the rights and safety of LGBTI people. When democratic institutions weaken, minorities are among the first to lose protection. The absence of strong rule of law guarantees and political commitment has led to several worrying developments: stalled legal reforms, tolerance of hate speech, weak judicial protection. Despite, as well as in the case of Hungary, despite judgments of the European Court of Human Rights, for example, the case of Koilova and Bobukova versus Bulgaria from 2023, which require Bulgaria to ensure legal recognition and protection for same-sex couples, and increasingly hostile environment for LGBTI activists and NGOs, as we see from even from yesterday. The struggle for the rule of law and democracy cannot be separated from the struggle for equality and dignity of LGBTI people without strong, independent institutions, and neither minority rights nor democracy itself can be safeguarded. Denitsa will point out examples from her practice as a lawyer and co-chair of the LGBTI organization Действие in this direction. So please, the floor is yours.
Thank you, Theodor. I just want to continue a little bit of what Esther said, and will give maybe one of the few positive examples that I have in my hands as a lawyer and legal representative of LGBTI people in many cases, court cases. Mr. Jonko Grozev will speak about the legal gender recognition and opinion of the Advocate General of the Court of Justice of the European Union, but I just want to give one example of a municipality in Bulgaria, a very small municipality, and I'm not going to name this municipality, but a very small municipality in Bulgaria, which we send the documents, the decision of court in Germany that the person changed their legal gender and the names, and we wanted this municipality to apply directly the outcomes of the Deldich case, and to, based on the decision of this German court, to rectify the gender marker and the names of the person, and they did it. They just asked for a power of attorney because we didn't represent it, and they did rectify the birth certificate of this person. And it is maybe the only administrative procedure, because Bulgaria requires court procedure to change the gender marker, but they did it in an administrative procedure. For us, it was very good development. In a pool of negative developments in the last years. So the same-sex individual couples and families in Bulgaria live in a complete legal invisibility, and I often say that LGBTIQ plus people in Bulgaria live in a legal vacuum. And I don't think this is an overstatement. There is no recognition of same-sex relationships in any form, neither marriage, nor registered partnership, nor even cohabitation. This means that same-sex couples are de facto deprived of over 300 rights, and this is according to a research that was published by the organization that I represent, these are rights related to inheritance, healthcare, taxation, social security, parenthood, and many others. Children in families, in same-sex families, are particularly affected by the invisible status of their parents. Despite the clear rulings of the Court of Justice of the European Union and the European Court of Human Rights, Bulgaria continues to ignore its legal obligations. And I'm going to give you a few examples of this. I'm going to start with the V.М.А versus Столична община район Панчарево, or the Pancharevo case, or also know the Baby Sarah case. We've been with Mr. Žalimas in the European Parliament talking a lot about the Baby Sarah case. Very short, the story, a Bulgarian citizen who moved to live in Spain. She got married to a British citizen who was a British citizen by descent. And in December 2019, a child was born, the baby Sarah, within this marriage. Baby Sarah was issued a Spanish birth certificate in which both of the parents were written as parents of the child, but as none of the mothers had Spanish citizenship, so the child could not obtain Spanish citizenship. The British mother could not transfer the British nationality to her child because she was a British citizen by descent. And if the child is born outside of the territory of the UK, the British nationality cannot be transferred. So the only option for this family was for the child to get a Bulgarian citizenship. According to the Bulgarian law, a Bulgarian citizen is every person whose one parent is a Bulgarian citizen. We started a procedure in Bulgaria. The Administrative Court of Sofia sent a preliminary ruling request to the Court of Justice of the European Union. And according to the ruling of the Court of Justice, in cases where a Bulgarian citizen has exercised her right to freedom of movement within the European Union, and while residing in another member state, a child is born within the same-sex family, and the Bulgarian citizen is registered as a parent in the birth certificate issued by this member state, Bulgaria is under the obligation to issue an identity card or passport for this child without firstly being required to issue a birth certificate. Well, this for us created a lot of hassles because as it was stated also by the judge in the administrative court, but also by us, the Bulgarian passport or Bulgarian ID card, in order to be issued such, the child must first receive a personal identification number. And in order to have the personal identification number, you first need to have a Bulgarian birth certificate. So it's it creates a bureaucratic deadlock, leaving dozens, and I say it, dozens of children stateless. We also have in our practice of the legal team of Действие many of such cases where children were left stateless because of this bureaucratic deadlock. In this case, in the Baby Sarah case, the Bulgarian Supreme Administrative Court refused to implement the judgment and effectively left Baby Sarah without nationality and without legal parents in Bulgaria. 5 years later, earlier this year, Baby Sarah got Spanish citizenship, but her court case continues before the European Court of Human Rights, together with many other applicants in a common case, which will maybe in 6 months the judgment will be published. Another negative example that we litigated in 2022, a child was born in Austria to 2 Bulgarian citizens, both listed as parents of the child in the Austrian birth certificate, and the Bulgarian authorities were informed who is the biological mother of the two women in the birth certificate, and yet the issuance of a Bulgarian birth certificate continued to be refused by this date, which left the child stateless for over 3 years now. Meanwhile, the Bulgarian administrative authorities continue to apply EU law selectively. If, for example, an EU citizen married to a same-sex partner from a third country, the Bulgarian authorities, namely the Migration Directorate, will grant residence rights for the in compliance with the free movement directive. But in the same case where a Bulgarian citizen is married to his or her same-sex partner from a third country, the same authorities will refuse recognition of this birth certificate and will not grant the third country resident residence rights. This is a blatant violation of the CG ruling on the Coman case of the Court of Justice of the European Union, and obviously of Article 21 of the Treaty of the Functioning of EU law, of European Union, I'm sorry. And in this situation where the Bulgarian authorities and courts continue to refuse to exercise their powers and fulfill their obligations under EU law, the judgment of the European Court of Human Rights on Kuyova and Babukova case provides a clear example how this systematic problem can be resolved. And I'm following here Esther with a little bit of positivity, although I completely understand how difficult this is. In this decision, the European Court of Human Rights states that Bulgaria must ensure legal recognition and protection for same-sex couples. And the court held that the complete absence of any legal framework recognizing same-sex relationships is a violation of Article 8 of the European Convention of Human Rights. And I completely understand that implementing this judgment requires a political will, which is obviously absent in Bulgaria at the moment, but basically for now, this judgment will remain the only judgment that can positively at least help the situation of for the dignity and respect of the lives of LGBTIQ people. For me, the Kuyova and Babukova judgment is a roadmap for compliance, and a roadmap that the Bulgarian Parliament and Ministry of Justice have to take clear steps in order to fulfill it. And just to conclude, in everything what I said in the beginning, with recent developments in Bulgaria and with obvious non-compliance with EU rulings that also Mr. Jonko Grozev will talk about. But these breaches, these attacks against LGBTI rights and deliberate depriving LGBTI people of rights falls within the scope of EU rule of law mechanism. and the Fundamental Rights Agency monitoring of civil society space. And clear actions needs to be done not only by the Bulgarian Parliament, by the Bulgarian Ministry of Justice, but clear actions needs to be taken on a European level against Bulgaria in order not to follow the example of Hungary. Thank you.
Thank you very much, Denica. I don't know if, probably you're very well acquainted with the facts, but it was not very clear from Denica's statement that actually she's the lawyer behind Baby Sarah case. So while we have such legal and human rights defenders and fighters here in Bulgaria, so there is hope. Both speakers in the panel were talking about outrageous behavior of institutions and actually people and administration and how they disrespect court judgments. But in Bulgaria we have a specific situation with the acting prosecutor general who thinks that the law is above him because the law says that he cannot continue taking this position outside of his mandate, but he's still there. So actually we have contributed a little bit also for this, how to call it, I don't want to make it hard for the translators, правен непокизъм, legal indifference, to be mild, but that is where we are. So we are continuing to learn more about not respecting court's decision and in this situation, and this presentation is going to be delivered by Mr. Jonko Grozev, who served as a judge at the European Court of Human Rights from 2015 to 2024, and before that he spent many years as a lawyer specializing in human rights litigation. His contribution today is particularly timely and necessary as Bulgaria is facing a moment of serious legal and moral challenge. For several years now, the Bulgarian legal community has been unable to find an adequate and broadly accepted solution to the question of the right of transgender people to obtain legal recognition of their gender identity. After years of gradual development of court practice that allowed trans people to change their legal gender through judicial proceedings, this process was abruptly halted first by a decision of the Constitutional Court and later by an interpretative decision of the Supreme Court of Cassation, which effectively blocked the possibility of legal gender recognition. However, these decisions will need to be reconsidered as they stand in direct contradiction with EU law and European human rights standards. In early September, Advocate General Jean-Richard Dulatour of the Court of Justice of the European Union delivered his opinion in Bulgarian case, the Shipov case, stating that the lack of any legal mechanism for gender recognition under Bulgarian law constitutes a violation of EU law. Perhaps the most important point in the Advocate General's opinion is that national courts cannot refuse to grant gender recognition on the grounds of legislative gaps. So, what shall we do? The floor is yours.
Благодаря. Да, благодаря най-напред за поканата да участвам в този панел и в това събитие и за възможността да обсъдим заедно, което ми се струва по-важното в този формат, какви са предизвикателствата, пред които сме изправени. Те са сериозни. Предизвикателствата идват от факта, че решенията на двете европейски съдилища и на Страсбург и на Люксембург не се изпълняват ефективно. Картина, която беше описана вече в двете предходни изказвания. И по-трудният и по-сложен въпрос, това съзнателно, целенасочено неизпълнение на решения на двете европейски съдилища има сравнително широка подкрепа в нашите общества. Това е трудният проблем, който в някаква степен ние се опитваме да прикрием, но той е реален и без да го кажем ясно, струва ми се, че всяка наша стратегия за действие ще страда от сериозен проблем. Какъв е проблемът, който се получава от това неизпълнение на съдебни решения? Той е двустранен. От една страна той е проблем от гледна точка на ефективното функциониране на правните системи. Правните системи се изправят пред предизвикателства, които неизбежно водят до конфликти на ценностно ниво, конфликти на норми на конституционно и европейско ниво. И тези конфликти неизбежно се превръщат в проблем в политическия дебат. И тук другият проблем, пред който сме изправени, е, че в този политически дебат неизпълнението на съдебни решения на двете европейски съдилища не носи еднозначна оценка от страна на избирателите. Или поне не носи такава оценка, която съвпада с начина, по който ние виждаме нашите страни и тяхното участие в европейските институции. И това е реалният проблем. Конкретният пример, той е просто един пример от немалко други, за който ще говоря, е признаването на смяна на пола в правните системи на отделни държави и как реагират в конкретния случай. Моят пример ще бъде на базата на български опит, как реагират институциите, българските институции, българските съдилища на този пример, на този проблем, извинявайте. От гледна точка на европейско право, проблемът е решен още през 2002 година с решението Кристин Гудуин срещу Великобритания, в което съда след много години разглеждане на същия въпрос постановява за първи път това, че тогава, когато има трайно установено идентификация с другия пол и това може да бъде проследено, това може да бъде доказано през фактите в конкретния случай, държавата има задължение да регистрира правно тази промяна на пола. В случая става въпрос за доста дълъг период, 20 години, включително и медицински промени от гледна точка на тази трансформация. Впоследствие подобни решения са правени по редица други оплаквания срещу различни държави, в които Европейски съд по правата на човека изяснява своята практика, в която приема, че тъй като става въпрос за сериозен, важен елемент от личностната идентификация, този проблем, този въпрос за промяна на пола е въпрос, по който държавите имат ограничена свобода на преценка и това е ключов елемент, защото в тази ситуация баланса между индивидуалното право на идентификация и на обществен интерес разглеждат по друг начин при тази ограничена преценка на съответната държава. Ограничената свобода на преценка в други ситуации ЕСПЧ е приел, че е широка. И в такива ситуации анализът за това дали има нарушение или не изглежда по различен начин. В различните случаи, които е разглеждал ЕСПЧ, нещата, които е взимал предвид е дали и колко продължителна е тази различна идентификация, доколко тя е установена. И тук съда приема, че има общ стандарт в Европа, дали има психическа експертиза, която установява този факт. И на базата на тези минимални изисквания приема че всяка една държава в Съвета на Европа, член на Съвета на Европа, има задължение да предостави процедура за промяна, която позволява такава промяна на пола. В ситуация, в която са засегнати и трети лица, Свободата на преценка на държавите е по-широка и там балансът може да е различен. В едно финландско дело искането е за промяна на пола. По-сложна е картината, но ще я го упростя малко. Признаване на пола, смяна на пола на лице, което е в брак, без да има промяна на факта, че има брак. И тук съда приема, че няма консенсус в страните в Европа по този въпрос и за това финландското правителство може да откаже такава смяна на пола, ако няма разтрогване на брака, като предварително условие. Този баланс, който прави Европейски съд по правата на човека в различните ситуации, е важен и от гледна точка на правото на Европейския съюз, тъй като тогава, когато въпросът касае приложимост на право на Европейския съюз, практиката на Европейски съд по правата на човека е приложима и от гледна точка на правото на Европейския съюз. Това проистича от хартата на основните права, основен принцип в правото на Европейския съюз. В този смисъл делото Кристин Гудуин е задължително и от гледна точка на правото на Европейския съюз, под условие, че въпросният случай попада в компетентността на правото на Европейския съюз. От тази гледна точка редица решения, които вече бяха цитирани, тогава, когато има за ограничаване на свободата на придвижване, съответно случаят попада в приложното право на Европейския съюз, задължението за такава регистрация е приложимо и Съда на Европейския съюз съответно е приемал решения, в които е постановявал именно това, че има задължение за такова прилагане. Тогава, когато обаче случаят не попада в приложното поле на правото на Европейския съюз, няма причина, поради която да има компетентност на Съда на Европейския съюз, съответно да е приложимо правото на Европейския съюз, и тогава няма съответно и такова задължение. На този фон на европейското право, българските съдилища и Конституционния съд и Върховния касационен съд приеха едни решения общи, в които приеха, че в България не може да има такава процедура по признаване на смяна на пола, тъй като това влиза в противоречие с основни конституционни принципи на българската конституция. Това създава сериозен проблем от гледна точка на съответствието и стиковането между българското право и европейското право. Как трябва да реагират българските съдилища, когато от страна на европейското право те имат задължение да признават такава смяна на пола, а българската конституция, която от гледна точка на правния ред в България е поставена по-високо в иерархията от нормите на международното право, забранява. Един състав на Върховния касационен съд направи искане до Съда на Европейския съюз. Предстои да видим какво ще е решението по това дело. Проблемът там е, че приложимостта на правото на Европейския съюз е не съвсем ясна и категорична. В други ситуации тя е, така че принципният проблем безспорно е налице. В конкретния случай това, на което стъпва твърдението за приложимост на право на Европейския съюз, е достоверност на информацията. Това е доста широк и по свобода на придвижване в една абстрактна форма. Това създава сравнително широко поле за разширяване на правото на Европейския съюз, което крие също съответни рискове. Дори да приемем обаче, че в този случай правото на Европейския съюз не е приложимо, общия проблем остава. И то е как българските съдилища трябва да се държат в ситуация, в която имаме ясен конфликт между нормите на българското конституционно право, така както го е тълкувал Конституционния съд, и европейското право. Защо това е проблем, включително и от гледна точка на наша гледна точка, на хора, които искаме да развиваме и да утвърждаваме защитата на малцинства, включително и на ЛГБТИ. То е проблем, защото основната легитимност на нашата позиция е правния порядък, върховенство на правото. И в ситуация, в която сме стигнали до това да имаме конфликт между Конституцията и правото на Европейския съюз, атакувайки този правопорядък, който е създаден от българската Конституция, в някаква степен ние атакуваме легитимността на собствените си действия. И това е един сериозен проблем. Другият проблем е свързан с това доколко ние можем да конфронтираме правото на Европейския съюз с българско обществено мнение. Това също е потенциален риск, за който ние трябва да сме доста бдителни и да внимаваме, защото възможността за развиване на права от горе надолу, без да се отчита готовността за възприемане и подкрепа от страна на съответното общество, е деликатен въпрос. Той е деликатен, включително и от гледна точка на съдебна практика. Европейски съд по правата на човека във всички свои решения, когато се е произнасял по тези проблеми, е обръщал внимание и на този проблем. И ключовото решение в това отношение е Олиари срещу Италия, където, приемайки, че има задължение за италианската държава да регистрира, да позволи регистрация на съжителство между двама души, независимо от тяхната сексуална ориентация, съдът приема, че изрично посочва, че това задължение следва и от италианското право, решение на Италианския конституционен съд, който е приел, че липсата на такава възможност е дискриминационна, и от гледна точка на демократичните принципи, доколкото такава регистрация се радва на широка подкрепа, мажоритарна подкрепа в италианското общество. С други думи, какво е общественото мнение, каква е готовността за подкрепа на едни мерки и в тази област, не е въпрос, който е изцяло и релевантен от гледна точка на приложимото право. Картината в други страни, за съжаление, е различна от тази в Италия. И това е фактор, който би било рисковано да не отчитаме в ситуация, в която основният стандарт, който прилагаме при защитата на тези права, е, че мерките трябва да са необходими в едно демократично общество. Така, малко с желание да провокирам и дебат, ще се радвам да продължим разговора и след това изказване. Благодаря ви за вниманието.
Много благодаря и аз. Значи, малко е като с въпроса за кокошката и яйцето, дали първо да променим общественото мнение, след това закона, или да си осигурим някакси спазването на някакви нормални стандарти европейски и след това да обясняваме какво означава това на по-широки групи от обществото, но действително, очевидно има пряка връзка между тези неща. We are going to wrap up this first panel with, I hope, some more positive insights and conclusions from Dainius Žalimas. It's my great honor to introduce Professor Žalimas, one of Lithuania's foremost constitutional scholars and distinguished defender of the rule of law and human rights. Professor Žalimas served as the president of the Constitutional Court of Lithuania from 2014 to 2021, where he played a leading role in shaping the country's model constitutional jurisprudence. He is currently a professor of constitutional and international law at V.М.А. Magnus University and member of the European Parliament. Professor Žalimas has been an unwavering advocate for the idea that constitutional and national identity cannot be invoked to justify discrimination or the denial of fundamental rights. His work emphasizes that the rule of law and constitutional democracy are grounded in human dignity, equality, and respect for diversity, principles that must protect all members of society, including LGBTIQ+ community. Professor Žalimas' intervention is particularly vital in today's European context, as we witness worrying trends in some democracies where constitutional values and the rule of law are being reinterpreted or even distorted to legitimize exclusion and inequality. His contribution comes to a crucial time, especially as we observe democratic backsliding in parts of Europe, notably Bulgaria and Hungary, where the independence of institutions, minority protections, and the principle of equality before the law face increasing challenges. In this moment, reaffirming the true essence of constitutionalism, that the Constitution exists to protect individuals from the abuses of power and the tyranny of the majority, is more necessary than ever. There's some very interesting developments in Lithuania concerning LGBT rights. Before the Constitutional Court, it's in regard to a landmark decision from 2024, when the Constitutional Court of Lithuania declared unconstitutional the long-standing provisions of the law on the protection of minors from the negative effects of public information. These provisions, in force since 2009, had prohibited the public depiction of LGBTI families, effectively silencing their visibility in media and public life. The court's decision not only restored equality in representation, but also reaffirmed Lithuania's commitment to international human rights standards following the European Court of Human Rights ruling in the case of Makate versus Lithuania from 2023. So how you achieved that? I mean, from 2009. It took a long time, but yeah.
Thank you very much. First of all, I would like to say that I'm honored to be here and very happy to share our experience. Also, I am very thankful to the organizers of this event. I think it is very important, especially in these challenging times, to address the issues of, let's say, eternal importance, because always such issues as the rule of law, relationship between the national constitution and international or European law, they are always in the focus of public discussion and the discussion between lawyers as well. And let me also express our solidarity, because currently I am in the European Parliament. I belong to the political group which is Renew Europe. It is a liberal group. Just recently it also established working group on following or monitoring situation in Bulgaria on the rule of law. And of course we are closely following all the developments in member countries. And I would like to express our support to the LGBTIQ community, also to the civic society in general in Bulgaria. And you can always rely on our, first of all, political support, maybe sometimes also on legal actions. By the way, what I heard here before, actually it's very recognizable. I think it is well organized externally, first of all, from such countries like Russia, with, first of all, a huge amount of disinformation about Istanbul Convention, about LGBT community which maybe you know in Russia has been declared as an extremist organization, although there is no such organization, first of all, but you know, it's the second enemy after Ukrainians. You can imagine that is real anti-human rights and aggressive ideology which is now prevailing. Also, civic society is being targeted in Lithuania as well. So the same disinformation narrative. So everything it's really recognizable. But what I also can understand, we have a little bit different experience. And you know, my answer lies why? Because you know, we are now speaking about non-implementation of Court of Justice judgments, maybe also European Court of Human Rights decisions by legislative or executive bodies, right? But we seem to forget about the third branch, that is the judiciary. So I mean, the answer lies why Lithuanian experience is a little bit different from the Bulgarian one. It's namely the judiciary, because actually what we have in public, I can tell you, according to the last public opinion polls, majority, let's say, I don't remember the exact number, 55% or so of population, they are opposing same-sex couples treatment as families. They are opposing Istanbul Convention, for example. But nevertheless, same-sex couples partnership is being implemented in Lithuania now. Nevertheless, as you mentioned, the Constitutional Court decided on the law on protection of minors, which is also very recognizable. It was directed against the so-called LGBT propaganda. So the Constitutional Court ruled this provision unconstitutional. Nevertheless, it is also the difference from Bulgaria, because I think Bulgarian Constitutional Court is the only one which proclaimed the Istanbul Convention contrary to national constitution. So Lithuanian Constitutional Court ruled, of course, in the opposite way, but it is compatible with the Lithuanian constitution. So, I mean, I don't know, of course, how to solve this problem, but when legislative and executive branches, they are failing in defending human rights, then the last resort is judiciary. And we must have professional, determined activist. By the way, I know that not all lawyers agree whether the court should be activist or not. I think Constitutional Court should be always activist, because otherwise it's not impossible to achieve the purpose of human rights implementation in any country. Activist, I mean, what does it mean activist? There's nothing wrong. It's just like one of my colleagues used to say, it just do your job properly. Implement your duties. What is your duty? To defend the constitution, the rule of law. So do what you can, actually, to the maximum, not restrict yourself. So that is, if you have determined independent judiciary consisting of high professionals, at least at the top level, Constitutional Court, for example, because I believe, like in Bulgaria, it's the same. I mean, who is responsible for the interpretation of the Constitution? Only the Constitutional Court. That is the only institution that is empowered to interpret the Constitution officially and in a binding way. Nobody else. No other courts. So I think that is the key, how sometimes human rights can be implemented even regardless the opposite public opinion. And I can tell you, just trying to be brief, how the Lithuanian Constitutional Court achieved this, because you know, any international legal provision, including European Union legal provision, finally is being implemented by national authorities. And here much depends on how do you perceive national constitution, because I believe, like I mean in Bulgaria as well, but in Lithuania, the constitution, you know, it provides also for the superiority of the constitution even over the European Union law and international law. It's quite usual in countries like ours. But I guess, of course, I'm not so familiar with Bulgarian case law, that interpretation here is a little bit different. So the Lithuanian Constitutional Court, first of all, found in the constitution itself the principles which are leading not to the, let's say, adversary interpretation, but first of all to the harmonious interpretation of the constitution in line with international and European legal provisions. And those principles, by the way, they are universal. The constitutions can be different in wording, that is natural, but in terms of values, they are not so much different, because you cannot say that human rights, they should be different in different countries. They are really universal categories of understanding of, the very understanding of the rule of law. It can't be also different in different countries. So maybe it's not a surprise. The first principle on which the Lithuanian Constitutional Court relied in interpreting the relationship between the Constitution and European and international law, it's the rule of law, very general one. But what is the rule of law? The rule of law is not only respect to national constitution, not only superiority of the constitution, but also respect to international law, right? It is also one of the elements. And you must reconcile within the rule of law that the superiority of the constitution cannot be opposed to the respect of international law. And here, of course, I can address about the so-called national values. I don't see in Lithuanian constitution, I believe there is nothing also in Bulgarian constitution of the national values you should defend against the European legal order. Maybe you can claim to the higher protection in certain fields, but how, you know, national, what kind of national values you can invent, which is really opposite to the European values. So that is the first one. The second, by the way, in the Lithuanian constitution, I don't know about Bulgarian, maybe it's also the provision. It is clearly provided Lithuania should implement in good faith all its international obligations, also stemming from a membership of the European Union. That is the constitutional provision. It should be also taken into account. And here the Lithuanian Constitutional Court simply went further. You know, if we implement international human rights standards or European human rights standards, can we really say that lower standards can be applied to our own citizens? It's really a wrong approach. It's not fair. And when we can come to the judgments of the Court of Justice, usually they have very narrow field of application if to look technically, right? Usually something related with freedom of movement. But once you recognize certain rights in the context of a freedom of movement, under the Constitution it would be, you know, not normal to say, but only in the field of freedom of movement we recognize the right to family reunification. But in general, it's not. So, you know, that is also the ground to expand a little bit the influence of, but of course it's national decision, it's the way how we interpreted our own constitution, that Court of Justice judgments, they have broader impact not only in the field of the European Union law, but also it has impact to the interpretation of the whole constitutional rights. Because otherwise, it wouldn't be fair. We would create two kinds of our own nationals. One, exercising freedom of movement within the European Union, then they are entitled to family recognition. And once, if you not exercising this freedom, you are not entitled to family recognition. That is, therefore, we call it sometimes the minimum constitutional standard. That is international and European law. And that's why it is becoming also the source to interpret our constitution. Because sometimes, you know, of course, the case law of national courts, it is less developed than that of European courts. And there is no need to invite a bicycle which is already invited. If it is already interpreted by European courts, there is no constitutional, first of all, there is no constitutional ground to interpret your constitutional provisions differently. So the third principle, I will try to be brief as possible, open civil society. I don't know whether its principle is provided in the Bulgarian constitution, but in Lithuanian constitution it is. So open civil society, what does it mean? It is open. Open to the international and European community. Once it is open, then the Lithuanian constitution should be also open. You know, that is also, they are mutually reinforcing all those principles. And the last principle, of course, it has certain specific history, national specific context in Lithuania. That is the principle of the Western geopolitical orientation. But I believe in similar manner in Bulgaria, there is also something in the constitution about your membership in the European Union, right? So in Lithuania, it is established as a constitutional imperative, as a constitutional value, and once you have in the constitution that you are fully fledged member of the European Union, you cannot interpret the constitution in the opposite way. Simply you cannot. The constitution provides for your membership. So that is also very important to say. And the second, maybe not the second, next thing which is also very important, it has been touched by you in your introduction, the very understanding of the constitution. Why do we need the constitution? It's more maybe, but it's not national, it's also universal concept. Constitution as anti-majoritarian act. The constitution is established not because to strengthen the majority, but on the opposite. Because to defend minorities, because to defend each human being against the dictatorship of majority. Once you take this approach, it's quite understandable why the Constitutional Court should decide the cases against the prevailing public opinion. And when the Constitutional Court decided that, because in our country, family in the Constitution is not expressly defined. In our country, what is expressly defined, that is the marriage, that you can't change without changing the text of the Constitution, I mean, between men of women, but family, it's broader concept. So therefore, the Constitutional Court said in a very simple way, the Constitution cannot contain internally any discriminatory provision. So if it is not otherwise provided expressly, then it means that it should protect all the families, including same-sex couples. Of course, in different form, not as marriage. Therefore, we have partnership, which is also now is being enforced by the Constitutional Court ruling. But nevertheless, the grounds of non-discrimination, they are expressly provided in the text. Of course, there is nothing about sexual orientation or sexual identity in the constitution which was written in 1992, but it is matter of interpretation. The constitutional court simply interpreted this provision, but it is non-exhaustive list of the grounds, because otherwise what we have, we will have internally contradicting interpretation of the constitution, but in certain cases discrimination is allowed. So anti-majoritarian nature of the constitution, and the last, direct applicability of the constitution. That is also very important. It should be reality. What I mean by direct? Of course, we don't expect from our legislature, who's now similar, I think, to the Hungarian one, even in Lithuania, because we have now the ruling majority that is really anti-European. But it can do anything against direct applicability of the constitution. The constitution is being enforced by the judiciary. When you can't rely on any law, you can go to the court directly relying on the constitution, also on European Convention of Human Rights and European Union law when necessary, and you can defend your rights. And here there are two examples. Just the most recent example is a number of judgments of national courts ordering to register same-sex partnerships, because still we have any legal provision on order, who should register and so on. So the courts directly ordering to register partnership. And the second, it is related to the gender reassignment. Already in 2007, maybe 2007 or 2009, we get the decision L versus Lithuania, where gender reassignment, I mean the duty of Lithuania to implement gender reassignment procedures was recognized, but still we have no national implementing legislation. When the persons concerned, they are going to the court, and the court orders to change your identity, for example. So both three essential elements: friendly attitude, constitutional attitude to European Union and international law, anti-majoritarian nature of the constitution, and direct applicability of the constitution. Thank you.
Very much. In my work, we meet with a lot of magistrates, people from the judiciary, judges, prosecutors, and I think that to some point it's also a culture issue, because I wrote down what you said, and I think it's very right, that just do your job properly. But when we work with magistrates, we have a pool of, let's say, trainings that we can offer, find experts, and the least they choose is European law or practice of the European Court of Justice. And it's a culture issue. They just don't like these rulings, and they say, no, we don't like them. We don't want to, apply them. So I hope, and what the representative of the French embassy said in the morning, it's also a question of how we transfer these values to the next generations that will get in the judiciary. So I think this is important also in our work. So we have some minutes for questions from the public. Има два микрофона, отляво и отдясно, на какъвто език искате. Заповядайте, да.
Здравейте, казвам се Вера Стаевска и миналата година имах удоволствието след основното ми социологическо образование да завърша една магистратура по европейско право и с този все пак ограничен капацитет, който имам, не мога да спра да се чудя къде отива примата на европейското право. Защо говорим за дружелюбно отношение на нашата конституция към европейското право, като всъщност той има примат над нея. Не става въпрос за международен договор, става въпрос за договорите за Европейския съюз. От друга страна, това, което каза господин Грозев, наистина е за мен пък като социолог много важно. Насилствено така налагане на отгоре на право не е дългосрочно ефективно. Наистина трябва да мислим за образователни кампании, но виждаме, че с години те не са достатъчно успешни, след като дори политически ни така наречен елит, някои от които наистина са образовани хора, не защитават тези каузи, така че това са два въпроса или по-скоро две теми, които за мен са важни във вашия дебат.
Още един въпрос да вземем и след това.
Сега да. Той е свързан, моя въпрос, може би, с втората част на предишния. Владислав Петков се казвам, благодаря за панела. Понеже в поканата беше за дебат по повод на това дали трябва да има обществена подкрепа за решенията и за насилственото налагане на право. Само една перспектива, според мен е важен този въпрос, трябва да го имаме предвид, разбира се, но една перспектива, т.е. не две перспективи искам да включа, докато го обсъждаме. Едната е, че ако продължаваме да мислим за общественото мнение като винаги изцяло отрицателно, според мен правим грешка. Ако погледнем данните на Евробарометър от 2015, 2019 и 2023 година, ще видим, че общественото мнение спрямо ЛГБТ правата всъщност се влошава. И това е насилствено, според мен, отгоре надолу, може би не насилствено, но е резултат на политика отгоре надолу във връзка с дебата за Истанбулската конвенция и въобще така политическата игра. И второто само, което искам да кажа е, че това, че на мен не ми се признава правото да живея в България с партньора си, е също насилствено налагане на право върху мене. Така че, нали, може би така. Добре, мерси.
Добре, има още два въпроса, но сега ще дам възможност да отговорят в панела. На първите два. Първия беше за примата на европейското право над националното. Това ми се струва, че може да направим 3-дневна научна конференция по този въпрос, но понеже Йонко Грозев, такъв въпрос му беше зададен в процедурата за избор за конституционен съдия, мисля, че има отговор, кратък, както беше отговорен тогава, не защото ние задавахме такъв въпрос с БИПИ, затова помня, към кандидатите. И ако иска професор Жалеман да отговори също на този въпрос. Заповядайте.
Съвсем накратко. Част от отговора на този въпрос, технически отговор е да, има примат и много ясен беше отговор, след като в българската конституция членството в Европейския съюз е записано. Конституционният съд има задължение да тълкува в светлината на европейско право и българската конституция. В този случай той не го направи. И всъщност това е ключовия проблем, пред който сме изправени. В някаква степен той е наш провал. Защо най-висшия български съд по този начин тълкува българската конституция? И отговорът не е прост. Той трябва да ни доведе до анализ, разговор за това как цялата правна общност, професионална, разбира, вижда, тълкува европейското право, какво не сме направили, за да няма по-добро разбиране на европейското право, защо средата като цяло в професионалната общност не позволява едно спокойно, естествено превеждане на европейското право в българското право. Огромна работа има да се върши и тази работа, имайки опита да работя и повече с български съдии, е на доста начална фаза. Ние имаме много работа да вършим в това. Много време сме пропуснали, за съжаление. И втория въпрос ще си позволя за реплика към коментара. Да, има право да живееш недискриминиран. Абсолютно. Аз на това съм си посветил живота. Въпросът е как да го постигнем. И ако губим битката за общественото мнение, тогава имаме проблем. И може би е добре да се фокусираме върху този проблем. Защо губим битката за общественото мнение?
Thank you. Yes, the question is so broad. Just thinking how to answer as shorter as possible. I fully agree with the colleague that it is, you know, a matter of legal culture and there reach of some sort of compromise in the legal community, first of all. And when we would have, I think, nice judges who could implement properly. Because just looking objectively, you know, I am an international lawyer, first of all. It was my diploma on international law. Later, of course, I came to constitutional court. When I somehow I was able to reconcile this. But sometimes when we have so hard and sharp disputes between constitutionalists and I don't know how to call them, international law scholars, and each side insists on their superiority, and they both are right, by the way. But because anyway, we should recognize in reality two things. First, you can always claim about superiority of international and European Union law, but unless you don't have national implementing authority, it will be highly problematic, yes. On the other hand, once you have also superiority of the constitution, but as I mentioned, for what purpose? What should we defend against the European Union? If we are, you know, basing our national constitution and membership of the European Union on the same values, they are not really different, those values. They can't be understood as different. Otherwise, you couldn't be a member of the European Union law, European Union at all. So that's why also important somehow to prove to constitutionalists that the constitution itself obliges you, because the constitution provides for the membership, fully fledged membership, implementing your obligation in good faith, it obliges to interpret formally, of course, of higher force, but still to interpret the constitution in harmony with the European Union law. Otherwise, you will never find the solution. And can it happen that despite all the efforts, there can be a conflict between European law and the constitution? Yes, it can, because both systems are parallel. I can mention one Lithuanian example, not related with the human rights issues we're talking about today, but from other field that was the consequences of impeachment. Due to parallel development of both legal systems, the conflict arose. I mean, the National Constitutional Court interpreted the provision of national constitution on impeachment that once the person is removed from the office, we get the president impeachment, by the way. He was removed from the office during impeachment. He suffers from life prohibition to take any state office again. And this has been recognized by the European Court of Human Rights as contrary to the European Convention of Human Rights as disproportionate measure. Not because of a lack of legitimate aim, but as disproportionate. You cannot ban the person to stand in public office for life. What did the Constitutional Court then? It proclaimed that this situation, of course, under the Constitution cannot be tolerated. It is a sort of anomaly, because the Constitution requires harmony. And that means that the Constitution should be amended, because otherwise this decision of Strasbourg Court couldn't be implemented. So, and the Constitution was amended. That is the way how we solve that. So, I mean, somehow we should seek through mutual dialogue, for understanding to each other, because actually I believe we are pursuing the same aims, both constitutional lawyers and international law. So we can able to reach a sort of compromise and a sort of solution how to solve this problem and really to make this conflict or potential conflict between European law and national constitution more theoretical rather than practical?
To give a little bit input from a human rights lawyer, so I'm not a constitutional lawyer or an international law scholar, and I want to reflect on the second question we got, whether this top-down approach is good or not, or whether it should be rather bottom-up approach. And I'm a human rights lawyer, so I would say no, you can't go to, bottom-up, because human rights should not be dependent on public support or the society's approval of something. And this is something that the European Court of Human Rights acknowledged several times. So I would say that like it goes hand in hand. So obviously you need raising awareness in order to get public support. But for example, Hungary introduced same-sex relationship, recognition for same-sex relationships first in 2008 and then 2007, but because it was too close to marriage for different-sex couples, the Constitutional Court quashed it. But for same-sex couples, it came into force in 2019. We were nowhere close to a public support. But had we waited at the time, we would not have partnership recognition, because in 2010, this government came into power. So, and then the public opinion changed, and in spite of the ongoing hate mongering and scapegoating of the LGBTQI community, in Hungary, public support is gradually increasing. And for example, same-sex parenting is supported by 3 times more in the society than a couple of years before. So it's almost 2/3 majority of the population who believe that same-sex couples can be good parents, and they never could adopt jointly or something. So there is nothing really which would I think push this change in the society. So I think you need a combination of the two, but there are cases when you need to go ahead with a top-down approach in order to get rights. And I don't think that anyone who is affected by this legislation would choose to live without rights until the majority of the society approves that. So I don't think that that's a good approach.
Thank you very much. Аз си мислих, че един от начините да решим проблема с евентуални конфликти между национално право, европейско право през призмата на конституциите е да приемем една европейска конституция за всички държави, където да се заложат най-високите стандарти по отношение на права, но очевидно това ще е политическа задача за бъдещето. Видях, че Елица иска да вземе думата. Днес публикуваха изследване за нагласа към демокрацията, мисля. Ако има някакви данни съвсем пресни по отношение на това, което говори, моля. Не съм го чел, само видях публикацията.
От този път е кратък доклада, може да се прочете лесно. Здравейте, Елица Маркова от Институт Отворено общество. Благодаря за тази възможност. Аз съм съгласна напълно с ограниченията на подхода отгоре надолу, но се изкушавам да задам един въпрос, на който нямам отговор, не съм тесен експерт. Как бихте коментирали писмото на господин Майкъл О'Флаерти до българските народни представители, което беше изпратено наскоро? Аз няколко пъти го отварях и гледах датата, но мисля, че нямаше грешка, което ми се струва, че не придоби особена публичност и в което, доколкото аз разбирам с моите ограничени познания, конкретно в сферата права на човека, той призовава нашите народни представители да не приемат поредните промени в Закона за училищно и преучилищно училищно образование, но ми се струва, че не коментира или по-скоро твърде широко споменава вече приетите промени в този закон за така наречената джендър пропаганда от миналата година. Ще съм благодарна, ако получа вашия коментар. Благодаря.
Още един бърз въпрос. Да, последен. Ради. Да.
It
can be quick, unfortunately. It's not really a question, it's more of a comment or provocation, let's say. The elephant in the room is, what do you do when you have something white, like this room, and your constitutional court says it's black? And that's a big question, of course. In Bulgaria, there are two institutions that can fix this. One is the parliament. It can amend the constitution, for example, or there is something called constituent powers, учредителна власт, we say in Bulgarian, in the constitutional law. So every body that adopts certain piece of legislation can give authentic interpretation of it. So theoretically, not that it's gonna happen, Bulgarian Supreme National Assembly could interpret the constitution and say that the concept of sex in it actually does not mean what the constitutional court said. But the more likely thing to happen is that the Bulgarian Constitutional Court, the second institution that can fix this, can adopt a new decision in future. So my answer would be that we should work on enhancing dialogue between constitutional courts and constitutional judges in Europe. I know there is some annual conference of constitutional courts or judges. I don't know what is their stance on this. I know that Venice Commission gave an opinion to Armenia, unfortunately 2019, a year after Bulgarian Constitutional Court delivered its decision on the Istanbul Convention. And in that opinion to Armenia, Venice Commission said that Istanbul Convention is not incompatible with the Armenian constitution in any way. Now we have decisions of other constitutional courts in Europe. So I say we should foster better dialogue between constitutional courts. We should foster better discussions in academia. There are some members of academia here, some of them very passionate about it. I see Velina Todorova shaking her head. So yeah, this is the short version of what I had to say. Follow me for more. Thank you very much. So I'll give the floor to all of the panelists for 1 to 2 sentences, remarks to Elitis, and if you want to add something to wrap it up. So.
In Bulgarian, I will address. Аз прочетох на Майкъл Флеерти това, което е написал, и всъщност, честно казано, то кореспондира в целият диалог, който се случва в момента в България и цялата насоченост на гражданското общество към промените, в новите промени в ЗПЛО, касащи вкарването на религията. И всъщност ние, масата от неправителствени организации забравиха вече промените в ЗПЛО от миналата година. И с това абсолютно се съгласявам. Но също така смятам, че проблема е един и същ. И той ще трябва да бъде адресиран вероятно едновременно с конституционно дело и с конституционно решение, което отново също така ще поставя една въпросителна предвид състава на Конституционния съд. Така че аз лично нямам едностранен отговор. По-скоро е реакция на цялостната политическа ситуация и по-скоро липсата на международна реакция на цялостната политическа ситуация, това, което и в началото адресирахме и което господин Славе също така адресира нееднократно в последно време.
Ако никой друг не иска да каже нещо, искам да благодаря най-вече на нашите панелисти за информацията, знанието и за вдъхновяващите неща, които ни дадоха като път за напред. Да благодаря на организаторите и на официалните гости за смисленото събитие и дискусия. Да благодаря, разбира се, и на публиката, че сте тук. Как да кажа, едва ли ще става в близко бъдеще по-добре. Според мен сме някъде в началото на трасето, където ще друса. Но мисля, че в България сме по-подготвени за реакция от това, което се случва в други държави. Така че трябва да свършим нашата работа правилно. Благодаря на преводачите и повече не искам да заставам между вас и кафе паузата, така че благодаря.